harassing the police every single day.
You get the whole thing.
Say hi, Andy. I'm recording you.
All right, you get the whole thing, right?
I got you.
Ocean City cops are not people.
Yes, they are. You know what's really criminal?
What's that?
Those knee-high socks.
I know, but that's what the brown shirts wore.
Hey, Charlotte County, this is Charlotte County COPWATCH. I'm going to make a comment on this before I read this document here, which bans filming public officials in a public place. This is the evil little fucking criminal, Jeanette Knowlton. She's a Charlotte County lawyer. And I want you to see this paperwork here. We got a tip from PUNTA GORDA that they were illegally trying to ban filming and then illegally striking our free speech online to get it shut down, which all of my shit has been shut down. Facebook, YouTube, TikTok, you name it. I knew it was a fucking government strike in my shit, and I still get striked to this day. I'm so shadow banned now, it's not even funny. But in giving us this document, we started to ask for records, and we found out this little criminal bitch, we knew it for a long time, but now we got proof, did not have this voted on when she banned free speech. If you look at the date here, November 20, 2018, when they originally passed the ordinance for rules in all the government buildings, this was 2016. We did not know that there is a law, a Florida statute law, Section 125.66, and which states any ordinance and or amended ordinance must be voted on. This little fucking criminal bitch never had the commissioners at Charlotte County vote on it, and I think they knew it. They are complicit also, and you're supposed to send it to the state, so it's on file. Here's the phone number. It is, I believe it is 850 245-6270. I've already called. I want everybody to call and say, what the fuck do we do about these criminals that did this shit? So what she did is she made it illegal to film public officials in a public place, and you will be trespassed. Tons of people have been trespassed. Tons of people went to kangaroo court. Nobody's fought it in state court yet, but this is damning fucking evidence right here. So when they were having their little powwow on with all the lawyers of Florida for county and city meet and talk about and have conventions on how to fuck people over. It's disgusting. And in that meeting, they talked about how to stop filming illegally. You have the right. Jesus Christ, at the fucking public building. So one of the counties wanted proof that she did this. So she sent this information over. And that's when we found out about this statute. Never knew about this, okay? So here's what she did. She did properly get the ordinance passed in 2016. It was voted on. But she did not, when she amended the ordinance with banning filming, she did not have them vote on it, and she did not send it to the state. Knowingly fucking did this. She needs to be bar-grieved and an ethics complaint, and I believe criminally charged and sued for all the shit that's happened since she passed this bullshit. Because this disease is spreading nationwide. You've heard a lot of auditors' channels saying, the government saying, you can't film me. Bullshit. But it's all stemming from this illegal act here. So that's why I wanted to give you an idea what's going on before I do the screen read on all this bullshit excuses that she used to ban filming. She twisted case law to ban filming, and it's not even fucking legal. Holy shit. So I will leave her information in here somewhere too. You can call Charlotte County. You can call, like I said, this government agency. This is absolutely criminal RICO shit. All these people and agencies working together. The sheriff, Charlotte County Sheriff Bill PRUMMELL, is involved in this. He's in the document where they are promoting killing filming. So anyways, here's a screen read. Everybody needs to check on this if your fucking city or county's doing this shit now too, because it is completely illegal.
Charlotte County Government to exceed expectations in the delivery of public services. www.charlottecountyfl.corn Memorandum. Date, to, from, subject. Or 2018-0746. November 20, 2018. Files County Attorney's Office. Trespass warning for public property. Constitutional requirements. 1. Liberty interest and due process. Individuals have a constitutionally protected liberty interest in lawfully visiting public property that is otherwise open to the public. Catron v. City of St. Petersburg, 658 F.3d 1260, 11th Sir 2011. Catron involved, inter alia, a constitutional challenge to the city's trespass ordinance that authorized certain city agents to exclude warned individuals from specific city land from 1 to 2 years, as well as the city's enforcement of that ordinance. ID at 1263. Despite this liberty interest, individuals do not have unfettered rights to use all public property under all conditions and at all times. ID, at 1266, 1267. This liberty interest may be forfeited, for example by trespass for cause, if due process is provided. ID at 1267. Due process requires notice and meaningful opportunity for a hearing. ID. Such notice and opportunity for hearing may. County Attorney's Office 18500, Murdoch Circle I, Port Charlotte, Florida 33948. Phone 941-743-1330. I fax 941-743-1550. Be provided post deprivation. ID at 1266.1. Accordingly, the county must provide due process in association with any deprivation of a liberty interest, such as through trespass. 2. First Amendment. Speech and expression. Owners of public property, as proprietors, have the right to designate their property for specific uses and to proscribe conduct that is inconsistent with those uses. United States v. Cokinda, 497 U.S. 720, 725, 110 S.CT 3115, 3119, 111 L.ed 2D 571, 1990, Uptown Pawn and Jewelry Incorporated v. City of Hollywood, 337 F.3D 1275, 11th Sir 2003, Iskin Miami Incorporated v. Metropolitan-Dade County, Florida, 147 F.3D 1282, 11th Sir 1998, and U.S. v. Gilbert, 920 F.2D 878, 11th Sir 1991. Government ownership of property does not automatically open that property to the public for all uses. Cokinda, Supra, 110 S.CT at 3119, United States Postal Service v. Council of Greenberg Civic Assens, 453 U.S. 114, 129, 101 S.CT 2676, 2685, 69 L.ed 2D 517, 1981, Cornelius v. NAACP Legal Defense and Educational Fund Incorporated, 473 U.S. 788, 105 S.CT 3439, 87 L.ed 2D 567, 1985. With respect to activities protected by the First Amendment, speech, expression, etc., the constitutionality of restrictions on access or use are dependent upon the type of forums existing on public property, i.e., traditional public forums, designated public forums, and non-public forums. Perry EDUC Association v. Perry Local Educators Association, 460 U.S. 37, 103 S.CT 948, 955, 74 L.ed 2D 794, 1983, Cokinda, 110 S.CT at 3119. A. Traditional public forums. 1. The Katrin Court found the St. Petersburg Ordinance invalid because it failed to provide a procedural means for a warning recipient to challenge the warning. ID at 1268. 2. Public streets, sidewalks, and parks are considered to be traditional public forums, where First Amendment activities such as speech and expression have traditionally occurred. To be constitutionally permissible, any government regulation of speech or expression within traditional public forums must pass strict scrutiny by the courts. Perry, 103 S.CT 948, 955. That means that in order to be constitutional, the regulation must be viewpoint neutral, narrowly tailored to serve a significant government interest, and leave open ample avenues for alternative expression. Perry, 103 S.CT 948, 955. Within these parameters, First Amendment activities are subject to reasonable time, place, and manner restrictions, which may be enforced without running afoul of the Constitution. IDB designated public forums government property that is not a traditional public forum but is intentionally opened up to the public for limited expressive purposes. For example, the Commission meeting room on board meeting days is considered to be a designated public forum or limited public forum. Perry, 103 S.CT at 955, Lamb's Chapel v. Center Mauritius Union Free SCHDIST, 508 U.S. 384, 1993, public meeting rooms are limited public forums. Roe v. City of Cocoa, Florida, 358 F.3d 800, 11th Sir 2004, public meeting rooms are limited public forums. Limitations on First Amendment activity in designated public forums are subject to the same analysis and restrictions as in traditional public forums. Perry, 103 S.CT at 955. See non-public forums. On the other hand, county buildings that have not, by tradition, designation or custom, been intentionally opened up for unfettered First Amendment activity are non. 3. Public forums. Perry, 103 S.CT at 955, U.S. v. Gilbert, 920 F.2d 878, 11th Sir 1991. In non-public forums, restrictions on First Amendment activities are not subject to strict scrutiny by the courts as they are in traditional or designated public forums. Rather, restrictions within non-public forums need only be reasonable in light of the purpose and use of the facility, in this case, the conduct of county business, and viewpoint neutral. Perry, 103 S.CT at 955, Gilbert, 920 F.2d at 884, Iskin Miami Incorporated, 147 F.3d at 1286. 3 Ordinance 2016-027 Trespass Warnings for County Property. On June 28, 2016, the Board of County Commissioners of Charlotte County, Florida, BOCC, enacted a trespass ordinance, Ordinance 2016-027, concerning county facilities. 1-2-82, Code of Laws and Ordinances of Charlotte County, Florida. The purpose of the ordinance was to maintain a safe and orderly environment which is conducive to the designated use of county property and to the efficient rendering of county services, to discourage unlawful, unsafe, destructive or otherwise prohibited activity on county property that interferes with the designated use of county property or the efficient rendering of public services, and to protect the liberty interest of persons on county property. ID. Only the county administrator, or his/her designee, has the authority to issue trespass warnings under the ordinance. 1-2-82, c. 1. The county administrator has designated the deputy county administrator and the assistant county administrator as having the authority to issue trespass warnings in the county administrator's absence. The Charlotte County Sheriff's Office, CCSO, has been designated as having the authority to issue trespass warnings under the ordinance only in cases where the 4. County administrator or his/her designee are unavailable. Any trespass issued is for a period of 1 year and applies only to the specific county property on which the prohibited conduct occurred. 1-2-82, C, 2, F, and C, 3. The ordinance provides a mechanism whereby a citizen who has been issued a trespass warning, but who needs to come to county facilities to conduct legitimate county business, may do so for those purposes only. 1-2-82, C, 3. A. The trespass ordinance provides due process. Finally, as required by Catron, the ordinance provides procedural due process via a specific provision for appeal of a trespass warning. ID, C, 6. Specifically, the ordinance provides for notice, the filing of an appeal and a time frame for the appeal process as a whole. ID. The appeal is quasi-judicial and heard by a neutral magistrate, who has the authority to control the conduct of the hearing. ID. Accordingly, the county's trespass ordinance provides appropriate due process when a trespass warning affects the liberty interest of an individual. 4 Facility rules. In addition to, and concomitant with, the ordinance, the BOCC enacted facility rules, which govern the conduct of citizens and persons using county facilities, the violation of which could subject an individual to a trespass warning. Point 2 The facility rules apply to buildings and property owned, leased, managed, or controlled by the BOCC, including traditional, designated and non-public forums. ID, B, 5, and facility rules. Generally speaking, the facility rules prohibit unlawful conduct and conduct. 2 The facility rules were amended on October 3, 2018. 5. That interferes with the orderly use of county facilities for county business purposes. Point 3 The facility rules also specify traditional public forum areas where First Amendment activity is permitted. Facility rules, as amended, Rule 6. The trespass ordinance and facility rules also provide for the issuance of a trespass warning for violations of the facility rules, after warning. Facility rules, Rule 15, 16. Finally, the facility rules are conspicuously posted in every county-owned or controlled building, as well as posted on the county's website, to ensure that persons using county facilities understand what conduct is prohibited. A. The facility rules are valid time, place, and manner restrictions in all forums. The facility rules ensure the county's significant government interests are met, that county property is reserved for its designated uses, county business is done in a safe, lawful, and orderly manner, and public services are provided efficiently. For example, activities typically undertaken in traditional public forums, such as petitioning, pamphleteering, demonstrating, or protesting, are not allowed inside of county buildings, but are allowed in traditional public forum areas, such as, outside of the entryway of any county-owned building, on any public sidewalk or public right-of-way near or adjacent to any county-owned building, or in areas otherwise designated for expressive activity. Facility rules, as amended, Rule 6. The only restriction is that these activities be done in an orderly manner and without harassment to employees or to the public. ID. These restrictions are entirely viewpoint neutral, in fact, no mention of viewpoint is made at all, serve the significant government interest of maintaining. 3. For example, Rule 9 prohibits, disruptive, harassing or unsafe behavior, including conduct which intentionally interferes with employees in the performance of their duties or intentionally interferes with the proper use of the county facility by others. Facility rules, as amended, Rule 9. 6. Order, and leave open all other alternative forms of expression. Accordingly, they constitute reasonable time, place, and manner restrictions, which are constitutionally permissible in these traditional public forums. Cornelius, 473 U.S. 788, 800, preventing disruption a significant government interest, Row, 358 F.3d 803, significant governmental interest in maintaining order, and Collinson v. Gott, 895 F.2d 994, 1000, 4th Sir 1990, providing order and fairness to all a significant government interest. With respect to designated public forums, example the BOCC meeting room on board meeting days, First Amendment protected activity is also allowed, subject to rules governing citizen conduct contained in the BOCC Rules of Procedure. These rules are viewpoint neutral, again, viewpoint is not even mentioned in the rules, and include limiting expression to the purpose of the designated forum, example county business, providing for a time limit for public input, 3 minutes, and ensuring safety and order. These restrictions are also reasonable time, place, and manner restrictions within a designated public forum and are entirely constitutionally permissible. Charnley v. Town of South Palm Beach, 2015 WL 129999749, SDFLA 2015. Finally, at the county, non-public forums include lobbies, offices, work areas, and areas not designated for public access. Gay Guardian Newspaper v. Ohupi Regional Library System, 235 F.sub.2d 1362, 1367 ET. SEQ, SDGA 2002, lobbies are generally considered non-public forums, Sefik v. United States, 1999 WL 778588, ND IL 1999, lobby in federal office building and non-public forum. These areas have never, by tradition or designation, been intentionally opened by the county for First Amendment activities, which is entirely within the discretion of the county. Cornelius. 7. 105 S.CT at 3477. The facility rules, as applied to non-public forums, are both reasonable. They simply require that visitors obey the law and not interfere with the use of county property for county purposes, and viewpoint neutral, again, viewpoint is not even mentioned in the rules. Accordingly they are constitutionally permissible. Perry, 103 S.CT at 955, Gilbert, 920 F.2d at 884, Iskin Miami Incorporated, 147 F.3d at 1286. Accordingly, the facility rules do not unconstitutionally restrict activities guaranteed by the First Amendment in traditional or designated public forums. First Amendment protected activities are allowed, consistent with each type of forum, with permissible time, place, and manner restrictions that serve significant government interests, are entirely viewpoint neutral and leave open ample alternatives for expressive activities. Likewise, the facility rules do not unconstitutionally restrict First Amendment activities within non-public forums, in that they are reasonable and entirely viewpoint neutral. Attachments. County Ordinance 2016-027, Original Facility Rules, Amended Facility Rules, and Trespass Warning Notice Form. 8.